Good evening, everyone. Thank you for joining us on this Sunday evening for this masterclass on fundamentals of pleadings. As you all know, we have a very distinguished speaker, and the format of this entire proceeding would be in a classroom format, whereas other discussions and webinars were panel discussions. But because of the choice of topic and the way we wanted to proceed with this, we have decided that it would be a masterclass followed by questions that we have received from some of you and some of our own questions. I also have a very able co-moderator, Dr. Amit George, who's a notable practitioner before the Delhi High Court. And I also have Ajay Thomas, the Director at Faculty of Law, Manav Rachna University. I would now request Dr. George to take over the proceedings and introduce the topic and the speaker.
Yeah, thank you so much, Shashank. Now, Justice Pradeep Nandrajog needs no introduction. However, in keeping with what is now a tradition in the webinar ecosystem, I would attempt to briefly summarize a long and distinguished judicial career in a few words. Justice Nandrajog, from the date of his elevation to the bench of the High Court of Delhi in December of 2002, in a decade-and-a-half long tenure, handled cases in virtually every jurisdiction that the vast and varied roster of the High Court had to offer. After a long and fruitful tenure at the High Court of Delhi, Justice Nandrajog was elevated as the Chief Justice of the Rajasthan High Court in the year 2017, and thereafter as the Chief Justice of the Bombay High Court in 2019, a position he held till he demitted office in February of 2020. Now, what is of larger interest for the purpose of the present session is Justice Nandrajog's sustained interest and advocacy throughout his judicial career for the need for improvement in the way pleadings are drafted and the necessity of going back to the basics. In fact, in the reference note for the present session, which has been shared with all of you, the judgment in Rothamberger India Private Limited, which is a mini treatise on the origin and development of the concept of pleadings, was authored by Justice Nandrajog himself. On a personal note, for those of us who have had the privilege of seeing him preside over his court, a recurring memory is of his consistent and frequent reference to the pleadings in the brief, while appreciating and engaging with the oral submissions addressed by the counsels. Therefore, while we are always undoubtedly honored to have Justice Nandrajog amongst us dehorse the topic of discussion, in the aforesaid background, we are especially enamored with the theme on which he has chosen to address us today. Now, to set the stage for the session, I may quote Justice Nandrajog's observations in CE Construction Limited versus Intertoll ICS, wherein while ruing the state of the pleadings before him, Justice Nandrajog observed, and I quote, "Before bringing the curtains down on the issue we are discussing, we need to note that the prolix appeal spanning 33 pages refers to discussions on subjects of law which have no concern with the issue. The appellant can be equated with a compulsive gambler who has lost his time, money, and energy in gambling and continues to gamble, hoping to strike the jackpot. It is the trait of such kind of litigants who border on being vexatious litigants, to use cliches and legal jargon, with prolix pleadings and all and sundry documents thrown at a judge, hoping that something may stick. The result is that they not only file confusing, lengthy, and repetitive pleadings, but also make submissions which are a strange mix of metaphors, requiring the same to be filtered to understand what they mean." Unquote. Now, in my view, they couldn't be a better allegory for the havoc that imprecise pleadings can wreak on an otherwise stateable case, and accordingly seal the fate of the litigant. And in this background, I would now request Justice Nandrajog to take the virtual floor and educate us as to precisely how to transition, in the context of pleadings, from compulsive gamblers to skilled craftsmen. Over to you, sir.
Good afternoon, and I hope that all of you are safe and in perfect health, and all those who are around you and associated with you, I pray for your well-being. I, at the outset, thank the organizers for having given me this opportunity today afternoon to join at this webinar and speak on a topic in respect of pleadings, which has always been a matter of great concern to me. Now, brevity is essential in life for one reason. Studies have shown that the concentration span of a human is 2 minutes. You would have noted that when a speaker is speaking with an eye contact with the audience, every 2 minutes, the audience starts looking on the left and the right, the concentration span breaks, and the audience looks back. You will also see that whenever a person is reading, after 2 minutes, the eyes blink, the reader moves his neck and, of course, the head left and right and regains the consciousness. So, once scientific studies show that the concentration span is so less, it becomes extremely imperative for the lawyers and the draftsmen to try and put their points in a manner which is as brief as possible. Actually, one of the inspirations for brevity came to me when I read a book written by an author on general observations in life. And he wrote that one day he fueled his car with high octane fuel, and the car was not well greased. The car kept on sputtering, and then he drew the analogy that high content information, if not put in a well oiled manner and presented briefly, would result in the same thing happening. The lawyer arguing in the court would be sputtering around. And of course, when your car sputters, the person who's sitting in the car is cursing the driver of the car and the car itself. Now, you see, for example, to make a statement, studies have shown that human society cannot function without an equitable distribution of resources of the earth. Very complex. Well, it could just be put simply, to be fair, we must share. Let's take another statement. By and large, it has been demonstrated that violence is counterproductive to the constructive interaction of persons and societies. True, but why can't it be simply put like this? Don't hit people. Bad things happen if you hit. In today's context, with the coronavirus around, well, the statement, the history of society is more defined by its understanding of disease than the formulation of philosophy and political theory. Why can't it be pleaded? Flush the toilet after you have used it and wash hands regularly. So, with this backdrop, we must understand that to convey something, to write something, for somebody to understand it is one aspect of the matter, but the thing should also make sense. In school, I remember there was a limerick, and it read like this. One fine morning in the middle of the night, two dead men got up to fight. Back to back, they faced each other, drew their swords, and shot one another. Well, the listener can understand what has been written, but it makes no sense. What if I was to start my address to you today by saying, ladies and gentlemen, I stand upon this speech to make platform. The train I arrived in has not yet come. So I took a bus and walked. I come before you to stand behind you and tell you something I know nothing about. We comprehend what it is, but it makes no sense. What I would be talking today is not simple, it is elemental. Pleadings. You have to pose three questions to yourself. What am I saying? What am I to say? And why I'm saying so? Answering the aforesaid three questions in a harmonious manner is the essence of pleadings. In the historical perspective, we would see and note that during the classical period of Roman law, disputes were defined in the formula, which was a written statement sending out in brief language what was the exact issue between the parties. The procedure was that the complainant would issue what was called as an in just vacatio, an informal statement of the nature of the claim, initiating the process of summoning the defendant to appear before the praetor, a high-ranking magistrate. The parties presented their legal pleas orally in turn. It was for the praetor to see that those pleas were accepted in law and were justified by some evidence. Once the pleadings had been heard, they were reduced into writing as the formula. Issue of the formula was litis contestio joinder officiis, which prohibited alteration of the pleadings and barred any further future action on the same issue between the parties. The formula stipulated to the judge, who was a non-lawyer, and the second stage of the system was the trial of the formula before him. English law was much less sophisticated in its earlier days than classical Roman law. Ordeals of fire and water, wager of law, and judicial combat settled matters and required no pleadings. Supernatural proofs and the oaths which were tested were absolute and inscrutinable. No legal questions were asked, no reasons were given, no facts found, no rules declared. However, in the 12th century, the advent of the jury as a more rational way of settling civil disputes brought pleadings with it. This was because just as the Roman judex had needed the formula, the jury had to know what issues it had to decide. The pleadings served another function too, because they disclosed whether the issue was one of fact or of law. Pleadings were conducted orally at the bar of the court and moderated by the judge until the 15th or the early part of the 16th century. The plaintiff first set out the facts of his complaint in what was known as the declaration or the narration or the count. The defendant had four options in making his defense, which were known as his pleas. And here we find the traces of the modern law of pleadings emerging. He could make a general traverse, which amounted to a denial of all the facts and make an issue of all of them. Or he could make a special traverse, which was a denial of one material fact, which was thereby put in issue, or he could simply demur, or he could make a confession and an avoidance. A demurrer admitted the facts but denied they amounted to a case in law, producing an issue of law without any facts in dispute. Confession and avoidance admitted facts but introduced new ones to explain them and make out a defense. Confessions and avoidance did not therefore produce an issue and required the plaintiff to respond with the same four options. The response was known as the replication. The pleadings continued called rejoinder, sur-rejoinder, rebutter, sub-rebutter, until the parties came to a point which is affirmed on one side and denied on the other. They are then said to be at issue, all their debates being at last contracted into a single point, which must now be determined either in favor of the plaintiff or of the defendant. Now let me illustrate. Let's take a plaint instituted where the plaintiff simply avers that I am A and I am carrying on business as a hardware merchant. B, who is the defendant, is a petty contractor and he purchases material from my hardware shop on a credit for a month. At the end of the month, we settle the account and he issues a check to me to satisfy the monetary claim. And for the month of March 2020, on settlement of the accounts, it was found that he had lifted material worth 1 lakh of rupees, and to tender the amount, he issued check number so and so, drawn on such and such bank from his account. The check on presentation was returned dishonored, and hence my claim for a dickery in sum of rupees 1 lakh with statutory interest under the Negotiable Instruments Act, which is 18% per annum. The defendant responds. He admits that the plaintiff is a hardware merchant. He admits that he is a petty contractor. He admits that he lifts goods on a credit for 1 month. He admits that at the end of the month, the accounts are settled and he squares up the payment due by issuing a check. But he brings pleas of avoidance. He says that this particular check I had issued to the plaintiff as a blank check when our business relationships commenced, which was 2 years ago, and I had given the check blank. He then pleads that during the 2 years period, he has issued 23 checks to the plaintiff. The numbers of the checks are so and so, to bring home the point that this check in normal course of business was issued 2 years back. He then pleads that in the month of March 2020, I lifted goods worth 1 lakh from the plaintiff's shop, but goods worth 50,000 were used by me for refurbishing the house of the plaintiff because the plaintiff had assigned the work of refurbishing his house to me. And then he says that during refurbishing, certain woodworks were required, and I executed those works by utilizing wood which was lying with me. And then he says that when at the end of the month I went to settle the account, the plaintiff turned dishonest. All the material he was putting to my account, whereas material worth only 50,000 was to my account. And then he says that my labor charges was coming to 30,000 rupees I had spent and utilized wood worth 20,000 rupees, and therefore I owe no money to the plaintiff. This written statement would require a replication with respect to the pleas of avoidance. Now let's take in the plea of avoidance. The plaintiff says, I deny that this check was not issued to me to clear the dues for the goods lifted by the defendant. He denies that it was issued as a blank check as a security. He admits that the defendant executed certain works in his house, but says that that material I had not taken into account when I drew up the statement of the material supplied to the defendant. On the labor charges, he says that the work executed by the defendant was shoddy. I had to redo the entire work, for which I would have an independent claim for damages. And since I cannot merge my different causes of action, and therefore I reiterate my claim. Now, this plea has admitted the facts pleaded by the defendant having executed the works in the house of the plaintiff, for which he had used the material of the plaintiff, but faced with the denial that that material was not accounted for by the plaintiff when he raised the claim, but he's faced with also the plea that he is not entitled to any labor charges and is not entitled to any sell-off. Now, the defendant has to file a sur rejoinder to these pleas, and suppose the sur rejoinder is a denial and a reiteration of his defense, then it can be said that parties have now contracted their pleadings where a fact is asserted and a fact is denied in a manner that trial can proceed. It would strike that the origin of pleadings was in a context where trade and commerce was not reflected in documents, where evidence in 100% cases was oral evidence to the extent of 100%. But today, we find that the position is nearly reversed. 7 except family disputes relating to partition and succession, we find that all commercial disputes are litigated on written documents, maybe a written agreement or a series of letters or emails exchanged. So in today's context, what should be the format of the pleadings? And there I find that there are some observations of the Supreme Court in a decision relating to writ pleadings, which would be, I think, very, very necessary in today's days context of commercial litigations. And if I may generally just read out from the court, the citation is 1988, 4 SCC 534, Bharat Singh versus State of Haryana. In paragraph 13, the Supreme Court observed, in our opinion, and I'm quoting, in our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or evidence in support of such facts is not annexed to the writ petition or the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is, a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such facts have to be pleaded and annexed. Just transform all this in the context of commercial litigation today. I think that what was said by the Supreme Court as the sine qua non for a pleadings in a writ petition would apply with a great force to pleadings today. If you look at the Code of Civil Procedure, we would find that the sweeping observations of the Supreme Court were a little out of sync with what the Code of Civil Procedure requires. I would briefly summarize and go through the provisions of the code which are relevant. So we have Rule 1 of Order 2, which requires the suit to be drafted so that by a single decision, all subjects in dispute are decided to prevent further litigation concerning them. Then we have Clause E of Rule 1 of Order 7, which requires that the plaintiff must disclose the facts constituting the cause of action and when it arose. Most important, which I find is generally missing in the pleadings these days, is Rule 5 of Order 7. It reads, the plaintiff should show that the defendant is or claims to be interested in subject matter and that he is liable to be called upon to answer the plaintiff's demand. In what manner the plaintiff holds the defendant accountable in law has to be pleaded in the plaint. Of course, then we have Rule 6, which talks of exemptions from limitations. We just talks about, and I'm not really troubling you on that. Then we have Rule 2 of Order 6. Every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense as the case may be, but not the evidence by which they are to be proved. I think it was this line which had led the Supreme Court in Bharat Singh's case to write that in a suit, the pleadings are different than the pleadings in the writ. But as we would find, if we go around a little further, we would find that this sweeping observation is not correct for the reason Rule 4 of Order 6 requires that in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms shall be stated in the pleadings. Order 6, Rule 9. You all forget that. Effect of document to be stated. Whenever the contents of any document are material, it shall be sufficient in the pleading to state the effect thereof as briefly as possible without setting out the whole or any part thereof unless the precise words of the documents or any part thereof are material. So it is not sufficient to talk about in a plaint or in a written statement that the plaintiff wrote such and such letter and the defendant replied by such and such letter to which the plaintiff responded, and endless. You have to come back and crystallize the pleadings, and the only way you can do it is that the exchange of correspondence is like a mother liquid. And if I could take the example of chemistry, you have to boil your liquid for the liquid to reach a point where crystallization takes place. So the mother liquid has to be first condensed to a stage where the crystal emerges. Your pleadings exactly have to do that. You have to boil the material, concentrate it, and reach the stage where the crystal emerges. That is the fact in dispute as it emerged from the correspondence exchange between the parties. That is a good pleading. So in today's context of pleadings, Rule 9 of Order 6 is the most important rule, which requires to state the effect of the contents of any document which are material, and it is this rule which in today's context requires pleadings in commercial disputes to be virtually the same as was highlighted by the Supreme Court in Bharat Singh's case for pleadings concerning writs. I had gone through as a lawyer and then as a judge pleadings which were so torturous, and invariably you would find in a large number of judgments that the issues which were settled on the pleadings have to be reworked upon by the judge at the stage of the judgment. And the reason for this is the prolixity of the pleadings and the non-focused approach, which unfortunately is the result of computers. If you would see the plaints of the time which were handwritten or when they were typewritten, the pleadings were more concise. This general habit of picking up verbatim contents of documents because you have them already on your computer and all you have to do is cut, copy, and paste is to be avoided. In fact, one of the finest plaints I came across was one drafted by a Mufassil lawyer in Agra. It was a suit for damages arising out of a dog bite. As I would tell you the contents of the pleadings, you would note that the author of the pleading knew the rules of onus, burden of proof, and how the onus and burden of proof can be set at a higher level. It happened like this, that the defendant's dog had bit the plaintiff. The plaintiff was a commission agent in cloth, so he used to carry on his business himself. He had to undertake a 14 days course of anti-rabies injections. And during the period, he had to undertake the injections because anti-rabies injections were not available in Agra. So he had to leave Agra. So he had a claim of quantified damages on account of loss of business for the days he had to undertake the treatment and the money spent on the treatment. He also had a claim for pain and trauma due to dog bite, which was the unspecified part of the damages. Now look at the plaintiff. The plaintiff resides in house number A, gully number B, and is carrying on business as a commission agent in Goa. The monthly earnings of the plaintiff are 75 rupees. Well, 1925 was the plaint and 75 rupees was a lot of money. The defendant has kept a dog known to be of an irritable nature. These words, known to be of an irritable nature. The lawyer knew that by and large, dogs have been domesticated over so many years, thousands and thousands of years, that they are by a class human friendly, but individually, some of them are not. He had in mind the rule of Raylan versus Fletcher in mind. So, by pleading that the dog which the defendant had kept was of an irritable nature, was a pleading which cast the duty of reasonable care to be taken by the owner of a pet at a higher pedestal. Then he pleads that on such and such date, as he was going for his morning walk, the dog pounced upon him. He didn't leave it at a simple statement and bit him, because he knew that for trauma, what would be the measure, the extent of the trauma. So he pleaded. The defendant's dog pounced upon the plaintiff and caught in his jaws the right wrist of the plaintiff. As the plaintiff wrestled to free himself, he tripped and fell down. The dog immediately released the grip of the jaw on the right wrist and clung on and bit the left thigh and then the right shin of the plaintiff. Continued trauma so that the judge could assess what damages could be paid for the trauma. He then pleads that the plaintiff was advised anti-rabies injections which were available in Kasoli, and then see the beauty, the nearest place available. He had in mind Section 73 of the Contract Act, which required mitigation. So he didn't leave it for the defendant to say, why did he go to Kasoli? He could have had the injections in Agra itself. So he pleaded the nearest place available for anti-rabies injections. And then see the further beauty in the simplicity. He said at Kasoli, the injections were available at the Hafkin Research Institute by the doctors to be injected only from Monday to Friday. So there were 14 injections because he had to justify a 21 days absence. He also pleaded that the journey by bus from Agra to Kasoli was a 14 hours journey. It took 1 day to reach there, 1 day to come back, 14 days for injections, 2 breaks in between. So such and such was the stay in the hotel. These were the boarding and lodging charges, and these were the charges. If a lawyer of 1925 could be so succinct about it in 2 pages, I think there is no reason why we today cannot be equally brief in our pleadings. It is simple, but it is elemental. Most of you who are arguing in courts realize that many a times the prolixity of your pleadings becomes the Achilles heels of the client. Now let's take a case in illustrativeness that what ought to be the core of a pleadings, and rather than being theoretical, because the provisions of the law of pleadings I have already brought out. Now let me give an example. If I pick up this glass of water, I don't have gin with me, but suppose I was to put some gin surreptitiously by keeping the glass hidden from the viewer and offer it to somebody to say that I think you're thirsty, please have a glass of water. After drinking water, the person realizes that he's been intoxicated. And he finds out that I have surreptitiously put gin in this water. And he sues me. What should he sue me on? Deception. Why? Because I took his consent to drink water, but I made him drink gin. He must make a pleading of deception. But while offering him water, situation 2, I tell him that, look, I'm putting some gin in this. The poor man doesn't know what gin is. I tell him, oh, it's nothing. It's just a supplement which makes the water a little tasty. Nothing would happen. And after drinking, he finds he's intoxicated. What should he sue me? Misrepresentation. Why? Because I took consent to drink gin. He consented to drink gin, but the consent was based on a misrepresentation. Situation 3. I tell the person, I'm offering you water. I put gin inside the water. Gin is alcoholic. It would intoxicate you. But I take out a gun and I say, I will shoot you if you don't drink it. So I've taken his consent to drink gin. I've taken his consent to drink gin with no misrepresentation, because I've told him that it is intoxicating, it is alcoholic. But I've forced him, and therefore the action would be one on coercion. It would not be based on deception. It would not be based on misrepresentation. It would be based on coercion. Situation 4. I tell him this is water. I put a gin in it. Gin is alcoholic. It intoxicates. I have a gun with me, but I'm not going to use my gun. Please, please, please drink the water. If you don't drink the water, my heart would be broken. I will feel very sad. You're a nice human being. Why do you make me sad? Please drink it. And he drinks it. Can you sue me? I don't think so. Why? Because I have just persuaded him. Now let's transform this into a real life example. You come across plaints where the plaintiff has agreed to a loan from a defendant, which is a usury loan. Let's take an example. The plaintiff says that one day in the morning when he got up, he got a call from the defendant, and the defendant said that I read the paper today and I find a surfacey notice that a property is being auctioned tomorrow at 10 a.m. The plaintiff says, oh, I never knew about that. He rushed to the bank. The manager said, look, we've given you all these notices and nothing can be done. The only way out is that before the auction starts, you pay. He goes back to the defendant. The defendant says, I would give you the money at 50% rate of interest per month. The plaintiff feels that the market is good. He'll be able to sell the property in 3 days. That doesn't matter. Even at 50%, what would be the interest on 1 crore which I'm taking? Hardly 30,000. No issues on that. He takes the crore of rupees, signs the bond to pay interest at 50% a month. For some reasons, he's unable to sell his property, and 3 months go by. So 1 crore has become 2 crore and 50 lakhs. There is no element of deception by the defendant. There is no element of misrepresentation from the side of the defendant. There is no element of coercion from the side of the defendant. Don't make in your plaint or pleading that he coerced me into it. Why did he? How did he coerce you? You yourself win. Your action has to be one then on equity. That I was so placed that I entered into a contract which was usurious. Take help of section 16, take help of section 20 of the Specific Relief Act, where a court would be justified in relieving a party of the obligation if the contract is found to be usurious. Now, see how good pleading sometimes can result in suits being decreed without a trial. Let me give you an example. The plaintiff is in the trade of wholesale business of bananas at the Azadpur Mandi in Delhi, and the defendant is also in the business of supplying bananas from the south. They've entered into a contract which requires that within 4 days of the delivery of the bananas, the plaintiff would pay the money for the bananas to the defendant. It happens like this, that on the third transaction, the plaintiff does not pay money within 4 days. The defendant sends a telegram that the 4th day is over, I haven't got my money. And on the 5th day, the plaintiff sends a telegram to the defendant saying that the bananas were rotten. On this factual backdrop, keeping in view section 42 of the Sales of Goods Act, which says that rejection of the goods has to be within reasonable time, and if the rejection of the goods is not within a reasonable time, the goods are deemed to be accepted. As the lawyer of the plaintiff, keep in view section 42 and keep in view that bananas, unlike apples, are highly perishable. In fact, they perish faster if kept in a cold storage. And therefore, a good plaint would draft that since the transaction was in bananas, parties agreed that 4 days is a reasonable time to intimate rejection. The rejection not being intimated within 4 days would require what? Would require something simple. If you see section 42 of the Sales of Goods Act, intimation of rejection within a reasonable time is a matter of law. What is a reasonable period of time would be a matter of fact. But if the plaintiff's lawyer in such case, such example which I've given, were to plead that the parties agreed that 4 days is a reasonable period of time for rejection of the goods, which even otherwise from a commonsensical point of view it is, and in such a case, even if the defendant were to take the plea that the goods, that the bananas were overripe, but if he admits that he intimated the rejection of the bananas on the 6th day after he received the telegram from the plaintiff that money has not been received, this case, as pleaded, would not warrant any trial to take place, and the plaintiff would be entitled to the suit being decreed. Meaning thereby, questions of fact attract issues of law. So the skill lies to merge your pleadings with the law, which would warrant the application of a principle to the fact for a judge to decide. It's as simple, it is as elemental. But the sad part of life is, and I don't blame anyone, that what is always missed is what is simple. And I would just narrate an anecdote and then close my talk to you, lest it becomes like a long drawn out monologue. The great detective Sherlock was one day on a hike with Dr. Watson. So they were in the woods up in the hills. They had camped in the night. At middle of the night, Sherlock shook Dr. Watson and said, Dr. Watson, what is your empirical evaluation? Dr. Watson looked up. He saw the sky. He looked at the stars, the position of the stars, and said, well, Sherlock, from the position of the stars, I can tell you that it is 5 minutes past 3 in the night. Sherlock looked at his watch and said, bang right, Watson, it's 5 minutes past 3. What more? He waved his hands and felt the air, and he said, from the chill in the air, I can tell you that the temperature is 7.8 degrees centigrade. Sherlock looked at the thermometer he was carrying and he said, bang right, it is 7.8. What more? He said, well, I was moving my hand, I could feel the atmospheric pressure, and from the atmospheric pressure, I could tell you that we are camping at 3,600 at 3,600 feet height. Sherlock looked at the barometer they were carrying, and bang, it was 3,600. He said, absolutely right. By the foot, you are right. What more? He said, by looking at the pole star and by looking at the other stars, I can tell you our location. We are 42 degrees longitude and 27 degrees latitude. Sherlock looked at his compass. Bang right. He said, what more, Dr. Watson? Watson said, I've told you everything. Sherlock said, no, you haven't realized somebody has stolen our tent. Thank you. Aman? Yes? Yes, Shashank.
Sir, Amit, would you like to go with the first question?
Yeah. So, sir, we've received a few questions from people who obviously gone through the lecture. Now,
Yes.
it's a very, very detailed lecture, but I'll just put a few queries which people who viewed the
Yes.
webinar have. So, one of the queries which has come forth is that unlike in the case of a plaint or a petition or a written statement, a rejoinder or a replication receives comparatively less attention when we speak of pleadings. So what are the aspects which are to be specifically kept in mind while we draft a replication or a rejoinder?
As you would have noted, I said that it will depend upon the nature of the written statement.
Right, sir.
If the written statement makes a general preverse, which is a denial of all the facts, then you don't need a replication. because you've already reached the stage where a fact asserted is denied. And such a replication, what do you find in the courts? Para so and so of the written statement is wrong and denied, and each and every averment or fact in the plaint is reasserted. Now, let us take if it is a plea of demurrer, no replication is needed because in the written statement, the defendant simply says, I admit all these facts, but in law, the plaintiff is not entitled to it. The replication would have importance if, as I said, that it is a case of a special traverse where a denial of one material fact which needs to be put. That's why I gave you that example of that case, the, the, the plaint between in a suit instituted by the hardware merchant. In such a case, when the written statement admitted that he had issued the check, admitted that the plaintiff is a hardware merchant, admitted that the defendant is a petty contractor, admitted that the defendant lifts goods from the plaintiff's shop on a credit for 1 month, and at the end of the month, the accounts are settled. And then he gives the justification that, look, I had done some work for the plaintiff, for which I had picked up the material from the plaintiff's house. The plaintiff even put that material to my account, which was not. The plaintiff was to give me money for labor charges, and the plaintiff was to give me money for the wood which I had used. Now, he has now put in facts to deny the liability, which the plaintiff would require to just to deal with. So that is where you also have the Delhi High Court judgment, which says replication is not a matter of right. Well, it's been put very broadly. I would put it very simply that if you can understand that the nature of the written statement, if it is a case of demurrer, no replication. It's a traverse of everything, no replication. If it is a plea of confession with avoidance, then the replication needs to be filed, otherwise not. The importance of the replication must come keeping in view the nature of the written statement.
Thank you so much, sir.
So, although the principles of CPC are broadly applicable to an arbitration proceeding, and CPC doesn't really apply on either the Evidence Act, but we are all guided by these broad principles while doing our domestic arbitrations. So,
Yes.
just seeking your opinion, sir, what is, in your opinion, a preferred mode of drafting a statement of claim between the usual alternatives that would be a detailed statement of claim with each of the documents ought to be filed, specifically described and marked, such as we do in a writ petition, or a brief statement of case with accompanying document merely being filed as a list of document without specific references in the body of pleadings,
Yes.
such as what we do in a case of a suit. So, as an arbitrator, what mode or what mechanism is more preferred?
Well, I will put it like this. It will make no difference as to whether it is a matter of pleading before an arbitrator or before a court. That is why I gave you the historical evolution of the law of pleadings, because as it says that the basis is that it must bring out the formula which the party knows is the formula which will be applicable, and the judge also knows that. What is given in the CPC is only formalizing which even otherwise existed in common law principles. That the rival parties, as also the person who has to adjudicate the claim, must know with clarity as to what facts are the parties at variance and on what issue of law are the parties at variance. That is why I also brought out to you people the importance of that Supreme Court judgment in 1988 for Supreme Court, that in today's context, where before the list has reached the court, parties have extensively exchanged correspondence, the rival versions on facts and on law, and the requirement of Rule 4 of Order 6, material effect of the document to be pleaded. So, simply put, the pleadings today, whether it is in a court or whether it is before the arbitrator, should focus on the, what I may use the expression, the signature tune of the theory of pleadings. They must bring out that what is the exact affirmation and denial of a fact with clarity, what is the exact affirmation and denial. And therefore, Shashank, you are right that there is no point to just annex the documents. Order 6 Rule 4 should be there, that the effect of the documents. The effect of the documents, let me illustrate. At the fag end of the contract, the defendant has raised a particular issue in the execution of, let us take, he raises the issue that the scaffolding, let's take a construction contract. At the end, he tells to the plaintiff that I'm not going to give you your money because I realize that the scaffolding which you had put before you cast the roof, when you laid your iron rods, was not properly put in place. Now, why should he claim, knowing fully well that this is the stand which the defendant has already taken in the exchange of correspondence, not plead and annex that the contract clause so and so required that before the plaintiff puts the iron rods, he has to put the scaffolding and give a notice of inspection to the defendant that I have completed the job of putting the scaffolding, and the defendant's representative came and okayed the scaffolding which was put. Then such and such term of the contract required the plaintiff to give another notice to the defendant that the iron rods have been laid and they have been tied, and the defendant's representative came and said, go ahead. And it was then that I laid the cement concrete mixture. So the effect of the two documents and the contract has been pleaded. So these are simple illustrations, but even in complex matters, it all needs. In fact, let me tell you one thing. In today's context, good lawyers should not even go to the court by a plain or a written statement. Why can't they follow an agreed statement of disputed and admitted facts to be presented to the court and asking the court, we want your judgment on these disputed facts, where this is the assertion and this is the denial of a particular fact, this is the assertion and this is the denial in law of that fact, and the material on which forms the substratum of the dispute to be placed before the court. It's absolutely simple. And let me tell you, Shashank, and all the viewers today, I've been hearing a lot of webinars on and this discussion which is going on, that in the post corona period, e-courts, well, then you don't focus. I don't think so that it would be possible to do effective and substantive justice. Decisions may come, but would there be just decisions? I think the load of the lawyers has increased manifold, and on a lighter vein, the fees have also spiraled manifold. So please justify the fee by an equal amount of labor.
Thank you, sir.
Right, sir. So now, if I could just draw your attention to an area which witnesses a lot of controversy, this is with regard to the permissibility of referring to the legal position in a pleading. Now, sir, the question was, in what cases, if at all, can there be reference to a case law in a pleading, or a statutory provision in a pleading. For instance, if I am articulating a preliminary objection on the strength of a judgment which introduced such a point in the first place, is it permissible in such a context to refer to the relevant case law? This is something we hear a lot of contrasting views on.
Yes. Well, the rules of pleadings do not conceive of a reference to a case law, but surely, as I said, and as you would have seen in my lecture, that the pleadings must bring out on what issues of fact and of law parties are at variance with each other. Now, to give an example, talking in the air is not. Is it a case where the plaintiff is talking of abandonment of the claim by the defendant? Is he talking of estoppel against the defendant? He must plead. And as I said, that if you would remember, I had talked about the provision of Order Rule 5 of Order 7, that in what manner the plaintiff is making the defendant accountable. So, to plead that the defendant at this stage is stopped from so claiming, because in reference to the correspondence exchange, he would bring it out that at the earlier stage, the defendant never raised an issue, but later on, he raised the issue. Would it be a case of estoppel by conduct? But let us take a case, he wants to plead abandonment. We all understand that abandonment as a principle of law is a conscious abandonment of a right in law. And an estoppel is something different. So my answer is very simple, that the law or the legal principle on which you are founding your pleading has to be pleaded. But to say that as in such and such judgment it was there, I think no rule of pleading warrants it. But yes, as we are evolving, in fact, it should be welcome in today's context. Why should the the defendant or the opposite party gains that it is on this judgment this person is so pleading, so that while answering, he's not taken by surprise. He says, oh, look, this judgment had these particular facts. But you have to be then careful. Then pleadings will become a mixture of your arguments and your case. So if you can skillfully omit the argumentative part of it, I don't think so there is any harm in it.
Right. Thank you, sir.
In fact, if it can be done with precision, it should be welcome.
Right.
Just a follow-up question on what Amit has said. So would it be permissible to extract relevant portions of the documents, for example, portions of the contract or the contractual clauses in the body of the pleadings? And if so, to what extent and in what circumstances?
Well, the answer is very, very simple. Again, I'll have to keep on picking up my the CPC. Now, when the CPC says that if I may just give you that example, which is stated there. So, for example, if there is a clause in the contract, which is a condition precedent, then Rule 6 of Order 6, which requires any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in his pleading by the plaintiff or the defendant, as the case may be, and subject thereto an averment of the performance or occurrence of all conditions. So therefore, how do you do it? So you'll have to say that there is a general condition of the contract, which is condition number so and so, which refers to a schedule of quantities. The clause is as under. The schedule of quantities is in part 4 of the contract. Relating to iron, the schedule of quantities inter alia provides this. So today what we find that in commercial contracts, it is, I think, imperative. And the reason would be that when we say wherever the contents of a document are material, that was order rule 9 of order 6. It says wherever the contents of any document are material, it shall be sufficient in the pleading to state the effect thereof as briefly as possible, without setting out the whole or any part thereof, unless the precise words of the document or any part thereof are material. So you see, there is enough space in the law of pleadings to prevent prolixity and yet permit, as what you said, that the exact clause, why not? If it says, unless the precise words of the document or any part thereof are material. Yes, you can. And you should. In fact, let me tell you, I've always maintained that every lawyer, when he gets the brief, knows with a reasonable degree of certitude where his client's case lies. That's the truth. And if you are the lawyer for the plaintiff, you know that the weight of your case is so strong that you will win. Your plaint should so narrate the facts that all that a judge has to do is like taking a knife and cutting it through butter. You can just recite the facts as they emerge from your plaint. And yes, if you know that your case is weak, then as a crafty lawyer, you are bound to plead it in a fuzzy manner. The skill of the lawyer for the defense should be, well, it is the job of the plaintiff's lawyer to confuse the judge. It is my job to diffuse the confusion. He must then put his preliminary submissions. A confusing plaint should always have the preliminary submissions, because sometimes to put it disjunctively, it becomes a little difficult for the flow to emerge. That is where skillful drafting comes. That's why I gave that example of that dog bite matter. That's the case of two instances of skillful drafting. That the defendant had kept a dog known to be of an irritable nature. I went from Agra to Kasauli, the nearest place. Yes.
Right, sir. Sir, I just had a follow-up question from one of our viewers. And sir, as you mentioned and consistently reiterated in your talk, that brevity and being to the point is, of course, a very essential skill set when you're drafting. Now, of course, even I recollect in my career, I've had senior lawyers who practice extensively on the civil side. One of them telling me that the best plaint he had ever come across was all of 6 pages in a partition suit. Now, this is quite elemental. But the difficulties for a lot of the younger bar lawyers who join law firms which deal with extremely high stake commercial matters, their experience has been that there is an increasing pressure to produce lengthy and complex pleadings. And in a sense, the length and complexity of the pleadings are directly proportional to the stakes involved. Now, this obviously introduces a certain peer pressure, which a lot of young lawyers inevitably succumb to, sir. Now, therefore, I'm asking you to restate the obvious, but coming from your experience, sir, what are your views on this?
Well, I have answered this many a times to young lawyers who have come to me and said, sir, we entirely agree with what you say on precision, but what do we do? You're right. You have to live in the world. You can't change the world. The rules of the fee are set by the clients. If you draft a 4-page plaint, he would say, oh, this is a 4-page plaint. And on a little anecdotal side, I'll tell you, there was a litigation in Shahjahanpur between the Birlas and the Goenka groups. and the Birlas had lost it before the sub-judge. So somebody referred them to me for an opinion, and I wrote an opinion, which was a very precise opinion. I brought out the law, and I wrote that it's a fit case to file an appeal, and you are sure to win. You got an excellent case. When I drew up my bill, the manager looked at me and laughed, and in Marwari he said, "Babu, thare ko fees na leni aaye." I said, "Why?" He said, "Lala bolega, my case is so good on law and facts. Why the hell am I paying this lawyer so much fee? So you please make an opinion which is long. Don't you come and say that you are a perfect case, but in the end, crystallize what we need, because they had only come to me for an opinion. They didn't want me to appear in Shahjahanpur at the district judges court where the first appeal would be there. So I've been telling the lawyers, do one thing, be a little skillful, satisfy the requirement of the ill wish of your client who would be satisfied with a 200-page plaint. Because he says, look at my contract. It's 400 pages. And there also you would find what is the data with us. An average contract in Europe is 40 to 50% less thicker than a contract which we see in India. Some lack of confidence. You would see in government contracts, huge NHAI contracts. After the contracts, letters are exchanged. And in the exchange of letters, some tweaking is taking place. I've told so many times, I've asked the lawyers, why could it at the stage of the contract an addendum not be drawn? And what is the contract bond? The tender documents as submitted, this letter, this letter, this letter, and 40 letters, everything are put in the contract bond. And you mess it around in the court. So answering your question, satisfy your client on the parawise reply, but neatly and briefly preliminary submissions. Briefly put the case of the plaintiff is this, and then elaborate it. Because I quite agree that you have to live with what the world wants, but not desirable. Somebody has to break this. I don't know how it started. It started like this. When I joined my senior, so you didn't have a reception outside his office. You didn't have a plush office. Just like if you would go to a doctor's clinic, till you wouldn't get I wouldn't say the smell of the medicine, I would say the aroma of the medicine, you would say what kind of a doctor he is. So simple, there used to be a table with a clean cloth, and right on top there used to be a bulb, and on the side there used to be a stretcher. That was a doctor's office. But then came the commercial world. So you had a reception. Now today when you enter a doctor's clinic, you get the fragrance of flowers, and I wonder, have I reached a florist shop or have I reached a doctor's clinic? I would be happier with a doctor where I get all the fragrance of all the medicines. I would say this guy is a better doctor. But then it doesn't happen like that. It's unfortunate. But you guys can try it. I'm sure that your clients, and a stage comes when your client starts trusting you. It happens. We also grew as lawyers. A lot of time the clients used to insist on being prolix, and when they would realize, but good. So when you would come out and you said the judge has given a date, he said, why is the judge given a date? He said, yeah, because my plaint is 200 pages. And now you see, I told you make it a 25-page plaint. You're responsible for this. So it gives you buffers. Do that, but not advisable. Not advisable.
So on the lighter note, just to add to what Amit was saying, in fact, in arbitrations, the lengthier pleadings is leading to a huge sum of reading fee being charged by the arbitrators. So I think that is also a consideration now. Lawyers don't mind making pleadings as long as the client is insisting on. But ultimately, client is paying for that hefty sum of reading fee which the arbitrators ask. And again, on a lighter note, the arbitrators ultimately, after hearing all the arguments, would say that please submit a 10-page or a 15-page skeletal arguments for the purposes of the award.
Right. It's like this. If you give me the contract to transmit 1 kg of wheat, and then the issue would be that was it husked or dehusked wheat, right? And somebody would say, well, whether it was 1 kg wheat just after the harvest, so whether it was with the stalk and whether it was with the shaft. So he said, I'm carrying 1 kg, but you made me carry the 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 stalk, you made me carry the shaft. And then at the end, he's right in telling you that I'm going to charge you because you made me carry a burden of 30 kg. And now, since my task was to separate 1 kg of the wheat from it, so he said, now you please do it for me.
So I
So
think
at base, let's all understand. It's let's at base we understand. Unfortunately, glamour, unfortunately, what is big has become the norm. So if you're traveling alone, I think a small car would be enough to cool you. And on Indian road, you don't need a BMW. So you need a big car, because a big car will get you a big fee. The client says that the lawyer with the big car is a bigger lawyer, so therefore he'll be entitled to a bigger fee. So on one hand, we are all talking of nanotechnology. We are all talking of the world shrinking. But on the other hand, we are all magnifying things. I think new generation lawyers, I think, should try to break the impasse. Try and make your clients understand that, look, at the end of it, this will be counterproductive. It would be counterproductive. And to give a little example, if the doctor says, take this pill thrice a day, common sense will tell you that why is he saying thrice a day? Because he requires a level of medicine to remain in the blood. And that's the theory. If the level of medicine falls from the blood, then the cycle is broken. Now, if he says 3 times, now it's for you then to decide. So he will just put 3 dots: morning, afternoon, night. Sorry. You will then have to redecide that I have 24 hours. I have to take 3 pills. How do I moderate my sleep now? So what you do is, so if you're an early to bed, you say, okay, I'll push it down by an hour, because the medicine has to be taken by me 15 minutes before my meal. Similarly, the morning one is 15 minutes before the meals. So when I give these examples, pleadings are also like that. I find many a times, I tell doctors, I said, you've given him this medicine 3. It's your duty also to tell him that should he take it 15 minutes before lunch and 15 minutes or 15 minutes after, because we know there are certain medicines which are digested on an empty stomach. Some of them are digested on a full stomach. Now, sometimes the doctor would say, take these 2 together. Have we asked him why? The doctor doesn't tell us why. We take one, and then he's supposed to tell you one is the digestive, one you have to take 15 minutes before, and the other. So you also, when I give these examples, so you're also doctors. You're also doctors. So you also have to tell your client. There's something like a knee pain, and the client is stupid. He says the pain goes out of the body. He says, "साहब मैंने यही सुना है, जिस्म से दर्द निकाल दो." So you can ask him 2 ways. भाई पाँव से निकाल दूं कि सर से निकाल दूं? Because if from the knee, if it has to be taken out from the head, it has to traverse a longer distance. So you get more fee for it. So it's humor, but then things said humor. I find that wisdom lies in humor.
so
Wisdom lies in humor, and you're right. You may lose your clients, but don't try it with your first client. after some time that the client gets at the sitting, he also starts somewhat understanding, and then you tell him that, look, this is the result of prolixity. And I think that there are people who are still willing for it. But as I said, it requires a lot of hard work at the beginning. What is here, I had been talking about this in Bombay, because you would see that I don't mean any disrespect to any category of lawyers anywhere, but what I find is that, and you also been practicing, both of you go to Bombay, the average pleading in Bombay is 3 times the length of the pleadings of similar kinds of litigations in Delhi. And the fear psychosis there is, they said, so the suits come for trial, and the listing is not as frequent on fixed dates as it is in Delhi. They said, so we are scared, sometimes we don't say something, and the charge of suppression of a fact is there against us. So I said, just for that small little ginning, you refuse to clean your lamps. You refuse to clean your lamps, and what happens? The genie never emerges. So I think the judges have to give you confidence, and you also have to give a confidence to the judge. There is a little mistrust on either side.
I hope Amit has got the message and he's not going to charge extra on account of his overgrown beard, because we were discussing that before the webinar started, his new look. Thank you very much, sir, for the great insight into the topic, and I assure all the viewers that the recording would be available shortly on various pages and on various groups where the initial link was shared. We also promised to come back and would request Justice Nandrajog to continue with the series of Back to Basics, because there is a lot that we have to learn. And sir has agreed, given the present circumstances, I think we will have to continue in the same mechanism, hosting webinars in the near future as well. Now I would request Mr. Ajay Thomas to give a formal vote of thanks on behalf of Maharashtra Universities and the organizers. Over to you, Ajay.
Thank you, Shashank. One of the great privileges of being the organizer is that one gets the opportunity to have the last word, literally. So my name is Ajay Thomas, and I'm the director of the Faculty of Law at Maharashtra University. On behalf of my colleagues at the faculty, I would like to thank today's distinguished speaker, Mr. Justice Pradeep Nandrajog, for bringing his great erudition to this event, and also for his excellent insights, practical insights into the fundamentals of pleadings. Many thanks also to Shashank Garg for actually conceptualizing the series of webinars, and to my good friend Dr. Amit George for his great research and superb moderation of this webinar. And last but not the least, a very big thank you to all of you attendees for contributing to the success of this webinar. And this webinar, as Shashank said, will be the first in a series of webinars to be organized by the Faculty of Law, Manav Rachna University, which would deal with fundamental concepts relating to the practice of law. So we look forward to seeing you all at one of our future webinars. Thank you, and I wish all of you a very pleasant Sunday afternoon. Thank you very much.
Thank you.